creates a community.
Oh, okay, then I'll look at that. Are you ready?
Give me a sign sheet.
We can start one.
Here you go, I got a piece of paper right here.
Mm-hmm.
What do you want on
I
it?
guess it's two.
Name?
Make two columns, and we'll just write under each column. One column is for the ATU, one column's for the county.
Yeah.
If I get a
Oh, my
copy of it,
pleasure.
too, Appreciate it.
So you just need our names on here?
A lot of folks in
Yeah,
here.
just name.
Don't know who everybody is.
Yeah, well, should we
Go around the room.
introduce ourselves? Yeah, I think we should.
So while that's going around, Mike, first let me just say that Curtis will be here tomorrow.
Okay.
He had an opportunity to resolve a big issue in North Carolina. So
Okay.
wanted to give him that opportunity to finish that up in North Carolina. So he will, I think he will fly in tonight and he'll be here tomorrow.
Good.
Hopefully, as long as that issue gets resolved. But, you know, when you can resolve something like negotiations, you want to take that opportunity.
Yeah, sure, for
So-
sure. That's good.
So
That's
he's
good
given
with
me
us.
some of the instructions of what he wants to see happen today, and we'll go
Okay.
from there.
Good. Well, we can start, Lorraine, why don't you start, and let's go around.
I'm Lorraine Hudson, I work for Pam Childers, clerk of the court and payroll department.
I'm Nikki Powell. I work with Lorraine in the payroll department.
Kristen Hewell, County Attorney's Office.
Oh, Gina Skilly, County Administrator. I thought you were going with. Should have known better.
I'm Mike Mattamore.
Pat Johnson, Waste Services Department.
Tim Day, Natural Resources Management.
Bob Dye, Facilities Management.
Paulette Stallworth, Human Resources Department.
Rory Riley, Piscataway Beach Public Works. Mike Lowry, President Business Agent, ATU 1395.
Adam Reed, Parks and Rec.
Lalonde Devon.
Steve Livings, Fleet Maintenance.
Michael Rhodes, Parks and Recreation Director.
Kenny Shelby, Parks and Rec.
Jamie Higdon, Public Works Fleet Management.
West Marino, Public Works Director.
Great.
Okay.
All right, well, welcome, everybody.
So as we get the list going around, so is there anything we want to need to start out with first, Mike?
I don't think so. We have created a whole book. But
We have two.
Good.
But we're not giving it all at once, but
Okay.
we've worked on it too as well.
Well, we don't mind actually giving it all at once. I mean, ours to you. You could give us whatever, you
Right.
don't have to give us everything at once.
Right, well, some of it, I'll explain why, as we
Okay.
go through, but, I thought maybe the very first thing we should talk about is the MOU that was sent to us, so we could clarify what that status is for the MOU.
Okay. Right.
And, I brought copies, but I didn't bring this many, but go ahead.
Okay. Is there more than one MOU, or is there just one MOU that's pending?
So, in early October, I received an MOU from, oh, I signed in the wrong spot, I'm sorry.
I'm glad you showed up, Yolanda.
Yeah.
Keep them straight.
There you go. So, we received this MOU
Okay.
via email, and you have a copy of it, or no? Do you need a copy?
I don't have a copy of it in front of me. If you give us one to look at, we'll give it back to you if you only have one.
No, we got several here.
Okay, good.
Here's some to start off with. If you need more, I got some more. But, and then I counted, Mike, with,
Here's some more.
I countered with, let me make sure I keep some for Curtis. And I gave you
Yonder.
that, right? Here's, and we countered with these. You did one, right, Steve?
Yes.
Okay, we got one project? Yes. So here's some extras for other people. You?
Yes.
So you sent over an MOU the county did,
Here's some-
regarding a 3% across the board pay increase. And that was, I'd have to look at the email date, Kristen, you can probably tell me, it's around, I think around October 7th or 8th, somewhere in that time frame. And then we countered back with, and I will say that this MOU that we countered back, I've made slight adjustments, because I told you I had a wrong date on there, so I made that correction. And we've added a sentence on there as well. So, the first thing that I wanted to say regarding this is that the concern here, to start off with, is that we see things a little differently than maybe some of the other unions when it comes to receiving something like this. We see it as an offered proposal across the table, and it's an across-the-board pay increase. So we feel that, statute 447 kicks in, and that we need to potentially counter, depending on what it says. And therefore, we also believe that while Mark Floyd tells me that you guys are not doing anything improper, in the sense that it's not legally wrong, he does say ethically, I don't know if this is the process I'm used to, which is that when something's offered, then we meet at the table and start to negotiate it. But it was sent over to me saying, if you will sign this, then by the 15th, it will be effective in the pay period for the blue-collar county workers. Number one, a concern to that, Mike, is that number one, our membership in the bargaining unit, as you know, the entire bargaining unit has the right to vote on and ratify such a pay increase. So we don't want to get caught up where we might end up with an unfair labor practice because we did not present it to the bargaining unit. So we feel that process has to occur before anything. We do want to offer up, and you can take a look at it and let us know what you think, but we think that there should have been some language added to it. We want to ensure that the 3% isn't the only thing that, while we don't want to take 3% off the table, we understand that the workers want the 3%. We also have negotiations just starting today. So our biggest concern is we have other proposals regarding Article 12 salaries. And so we don't want to waive our rights, so to speak, to say that we're not going to be able to offer any more proposals. And so we feel that we wanted to be clear and on the record that we are wanting to work out this MOU with you to ensure that the workers get the 3%, but we also want to ensure that it's not going to be, from your point of view, that we're taking the position that that's all we're going to be taking is the 3%, because there are some concerns about wage structures and things of that nature, language as well under that article.
Okay.
Okay?
Okay, I think I understand what your position is. You want to work out and execute a memorandum of understanding that would put this pay increase into effect, but you want to go through the ratification process first. And secondly, you want to know our position as to whether this is a resolution of wages for 1920 or whether it's on top of anything else that's negotiated.
And to add to that, Mike, we're hearing all kinds of different stories behind it. I mean, the way I read it, it says across the board pay increase. But we're hearing, whether it's from the other unions, talking to them, or whether it's on social media, or whether it's looking at the news articles and seeing the people put things down, it's being construed as a COLA, a cost of living adjustment. And to us, that's a little different than what an across-the-board wage increase is. Some might argue that they both could be considered the same, potentially, but we want to make sure we understand what your thought process was to offer up this prior to negotiations. And so that's what we're wondering.
Okay.
Okay?
All right. And sounds like you want to have the county's position articulated before we go to the next step of negotiation. So if that's the case, I guess we need a caucus.
Yep, I understand, and since we're the smaller group, you said you might have an extra room for us
Yes.
to go into?
2 doors down on the right,
Two doors down
room
on the right.
115.
Okay, thank you, appreciate it. All right, Mike.
Okay, so, there, a couple things. One is that we wanted to identify, for your purposes, that the other units did not ratify the MOU that we sent them. They just signed it and sent it back. And we're gonna, we're going to talk about this in just a second, but, and I guess if you needed to be ratified, it would have been great if it had been ratified, since it was sent over around 10/3 to today. But if you feel like you need to ratify it, that's your business. And, that's, we're not telling you to ratify it or not ratify it.
Okay.
It's not our intent that, and it's not reflected on our memorandum, that this is a waiver of your ability to continue to negotiate wages.
Okay, good. Okay.
I don't know how much of a difference it makes, but this is a 3% across the board. It's not a COLA. Traditionally, a COLA is tied to an index,
Right.
and this is a 3% increase.
Right.
In wages, it's not tied to any index. Now, we do not have direction or authorization, one way or the other, for retroactive pay. So, sitting here today, we cannot spend that money. But at the same time, I'm not saying that if it was brought to the attention of our clients, that they would not be amenable to it. We just don't know. Now, I guess, how that leaves us today is, we could always sort of separate out the issue of retroactivity and discuss that after we've had an opportunity to talk to our people, and go ahead and sign a memorandum of understanding that would have the increase effective upon your ratification.
Okay.
So the retro piece would just have to be dealt with later, when we get some direction.
So you're saying that basically that the retro piece would be after you go back to your, when you say client, I'm assuming that means the commissioners.
That's correct.
Okay. Since the county administrator is sitting here, so I'm
Yeah.
assuming that what you're telling me is that she can't make that decision, it has to be those commissioners.
Yes, to spend that kind of money, because there wasn't really anything that had been, that we've discussed with them.
For retro pay.
Yeah.
Okay, so let me make sure I got this straight. So you're saying that it's not your intent to limit our waiver, us from having to negotiate any further proposals on wages
Correct.
or language
Correct.
within that salaries article?
Right, right.
Okay, and also you're saying that obviously it's our ability or choice to take it back to be ratified. And then you have the no retroactive pay. I do have one more question on the across the board. So on the across the board pay increase, under it, I'm not sure, but I can assume, and I don't want to assume, that's why I brought it to you for discussion. Is that only for active employees, or is that across the board raise on all pay scales? Meaning a beginning wage as well, meaning the starting wage of each classification, is that being raised 3% as well?
I don't know, I would think
No,
that
it's-
just.
No, it's not being, at this time, it's not.
Yeah, I think if we were gonna change the wage scales, we would have sent that
Correct.
along with the memorandum.
Okay, Okay, so why don't we, so was there any response to our counter to that language?
We think now that I've explained this and we're on the record and we're being recorded, like, we actually are there is a record, like
The camera, too.
like an LP,
Huh?
like an LP.
Yeah.
8-track.
8-track.
Oh, wait.
What we would suggest, the best way of doing this is to change the effective date of the memorandum of understanding and just make it effective upon ratification and sign what we had sent over, because that's 3% across the board. And, we've gone on record as saying that it's not a waiver.
Right, but you also said that you'd have to check with your clients to see if there's retroactivity. Is
Yes,
that-
so it would say with the next pay period after ratification, the first pay period after ratification is what we could.
The 3% would go into effect. Whether there's retroactive pay or not would be something we could take up later, is what I'm saying, when we got direction. I don't know exactly the timing of that.
Okay.
But it would allow the 3% to go forward for now.
Right, okay, so we'll discuss that.
Okay.
When we get a break, we'll discuss that. So let me ask you another question, which might be important, because I'm hearing from different bargaining unit employees, some already got the 3% in their in their wages, and some didn't. I think there's probably later on, we're gonna have to clarify to be sure we know what who's in the unit and then who's not. Because, for instance, I think there were some lead techs
Right.
that got the 3%. And obviously, under the labor agreement and under the PERC certification, lead maintenance technicians are part of the bargaining unit. So there's never been a unit clarification on that.
There has actually. The
There
last
has.
order was in 2010. In fact, Mr. Mattamore represented the county, and the ATU was a party, and that lead position was not in the unit.
Okay, so we'll go back and look at that, because what we've looked at through PERC is that it was. So we'll look at those classifications to verify which ones are and which ones are not. So
We verified it, as did the clerk's office, when
Okay.
those 3% were assessed.
Okay, well, we'll review it. Has there been any other name changes of classifications that have been done, or?
We also consulted with Human Resources, and to our knowledge, the positions that were included in the list attached to the 2015 agreement had been created since the unit clarification in 2010. So they did not even exist when that last order was issued by PERC defining the unit.
Okay, so the labor agreement you're referring to, this one, right? Is that
I don't know what that is.
the last contract?
Is it dated in 2015?
It goes, 2015?
Mm-hmm.
So, okay, so we'll review that, because I can pull up the PERC certification online.
Mhm.
That's fine. And you said lead fleet maintenance technicians were not included in the last one in 2010?
That's correct.
Even though in 2015, this labor agreement has them listed in it?
The PERC order
I
is
got it.
dated in 2010, defining the unit. That's the last order defining the unit. The
I-
agreement does not govern in terms of defining the unit.
I get it, I'm just saying that in 2015, why wouldn't we have updated it in the actual labor?
I don't
have
know.
We don't have an explanation for that, Mike.
Okay.
I don't
That's
know
fine.
why those classifications were included in that list in the 2015 agreement, but it doesn't define the unit.
Somebody could have just rolled forward an old appendix. Who knows?
Sure, so we'll go back and look at it.
Yeah,
I mean,
yeah.
Obviously, I know there was a unit clarification in 2010.
Yeah.
So we'll go back and look at that. That's not a problem. All right, so we'll respond to the MOU.
Good.
After we have a little break. There might be a chance after I reach out to Curtis and see what he says. He might want to wait till tomorrow on
Whatever.
that, when he's here, potentially. So I'll wait and see after we talk to him on that.
Okay, good.
Okay? So do we want to move into what we're gonna pass across the table. Looks like you have your version and we have ours.
Yeah, that's good. I think we might as well. Let's make as much progress as we possibly can.
Sure. So, I didn't bring, I think we brought 10, that was the number you gave me. I didn't bring enough for the entire room, but I did bring what you told me was 10 individuals. And I'm gonna make sure this is it. This is
Well, we just turned it into a party.
Did
so-
you? Okay, that's fine. That's fine. So, I did provide color for some of you, but then I thought, well, wait a second, now, I don't know if I want to provide colored copies to everybody. You're gonna give us yours at the same time, Mike? Is that right? And here is one for her as well.
Let's see.
There's an extra one, who wants it, Lori? And then there's all these are black or white, but you'll be able to tell because they're shaded, the changes are all highlight shaded, okay? I'm sorry about that.
You guys want to share?
Now,
Let's see, 1, 2, 3, 4, 5.
We're,
so I will say.
5, yep, see, there's making sure that you have the first
All right,
5.
very good.
Can I get that extra one again, Kirk?
Yeah, for
Yep,
courtesy.
here you go.
Thank you.
Okay, now you and I will share that. Okay, so you can pass some that way, and I'll pass
You
you
did?
this. There you go.
Okay.
here's some extra.
Mike's got one.
Okay.
I got one.
Are they sharing
So-
there?
No, I think they all have it now.
Unless I made it.
Okay.
So Mike, just for, do you want to
Oh, I have
like
one too.
present your changes to us? You want to go first and present your changes that you made in yours, or how do you want to do this? I think it might be good for our side, because our version of it as well, but.
Okay. Kristen, do you want to run through that?
Sure. Article 2,
Second to catch up. All right.
is standard language, referencing the most recent PERC order defining the unit. Article 3, general provisions, really just a lot of cleanup.
Okay.
Article 4, same, clarifying where the bulletin boards are, including some standard language, let's see, dues deductions. We do have a new provision on the union leave. Grievance procedure was honestly just a lot of cleanup to be consistent with all the other labor contracts.
Okay.
Discipline. More cleanup. Rather than including the violation reference codes in the body of the agreement, I cut it out into an attachment, which is here.
You're talking about the recommended guidelines?
Yeah.
And we have revised it to include the codes and
Do
not,
you have a version of that that is not, I mean, I don't have an actual
Yeah,
version of this.
yeah.
I have a PDF and
That's
that's
what she,
have
it.
a
the
PDF.
PDF.
And it's actually got underlines and stripes on it for whatever reason, and that's,
I think I'll reach out to the staff.
The
see
best
if they
thing I
it.
have.
I think they might have it, I'm not sure, so I'll reach out to them and ask them. Because we weren't able to, I mean, unless we would be able to change that. Is that for us to get a copy of, like this?
you want one?
Thank you very much.
Article 7, seniority, just more cleanup. Article 8,
Let me catch up, hold on one second.
Page 18.
So that's 7, okay, 8,
8 is just referencing the Human Resources Policies and Procedures Manual to ensure that it is all-inclusive of all the leaves that are offered to other classified county employees. There's standard language added regarding unscheduled leave time. And I did want to mention that we would like to revise what is included in this as compensatory leave at the clerk's office's request to coincide with their current practice.
Okay.
So that would be all compensatory leave not used by the first payday in September will be paid by the last payday in September of the fiscal year.
Got it.
Article 9, personnel records is just cleanup, very minimal. Article 10, hours of work and overtime is cleanup. I struck the provision carving out what is referred to as designated holidays only because it created confusion, but not to change the intent or the current practice as it relates to what you will find, let me see, where is it? Yes, on page 28, Article 18, in terms of holidays and how holiday pay is paid. The language didn't actually capture the current practice, which is to treat holiday pay as hours worked and holidays for time that is actually worked is paid at the regular rate of pay. So
Right, I got it. So
that's I tried to clarify that in the contract language, but
So
they're.
basically, from the perspective of a worker, it's 2 times. It's
Correct.
Right.
But the clerk's office had issues with the wording in the contract because it was not terribly clear. So, Article 11, management rights, is just standard language.
Okay. What is the underlining? I'm just curious. Is that
That's
just-
added to, and
It's
it's
added?
intended to be added to, everything that I've added is underlined.
Okay, and then everything that's yellow?
Yellow, I
Is this
highlighted the
appendix?
Yeah,
appendixes just so
Okay.
that they're easy to reference in case we need to change
Okay.
anything. 12, wage rates were actually not, I think they were previously attached as an appendix. And so I've now referenced that in the contract and referenced the appendix, which will be attached with the pay grades.
Okay.
And I've created an attachment for the pay grades
Okay.
with the correct job classifications. That's enough.
I've got one, yes. There you go.
Article 13, reduction in force, just clean up. Article 15, same, just clarified the language. 15, miscellaneous benefits, tried to revise it so that it's consistent with our current accounting policies and current practice. 16, insurance is cleanup. 17, paydays, same, clarified the language. 18, I already mentioned, in terms of holiday pay. '19, probationary period. I believe this was just cleanup. Let's see. Uh, 20, out of classification pay. Attempted to clarify the language consistent with the current practice. 21, of course, is subject to change depending upon whether we want to include reopeners, but as drafted, it's just a 3-year term. 22, successor clause. 23, totality of the agreement is just cleanup, and that's it.
Okay.
Thank you, Kristen.
Sure.
All right, as far as the union side, for what we gave you across the table. Let me know when you're ready.
I think we're ready.
Okay, so Mike, we gave, obviously, the cover sheet and we gave a table of contents, but we didn't put the page numbers down because we assumed that it's going to change.
Okay.
And that can be corrected as we go forward. All right, so Article 1, the contracting parties, we just changed it from 1771 to 1395. And then under recognition, we did something similar to what she did, which is added the PERC certification, but we also added some information down below regarding the changing of any job descriptions or anything of that nature, so you can review that to see what we put in. And then, and we've asked that quarterly that we receive a updated bargaining unit list that will include the following items, which is the employee's name, classification, hire date, department, address, et cetera, et cetera. I will say that we need that now for negotiations. We need specifically right now, we need the entire bargaining unit, their names, their job description, their hire date.
I believe you already made a public records request, and we provided you with all the documentation that we
The hire
currently
date,
have.
though, is important.
If we
to
don't
us.
have a record that we can provide, then
So for us to be able to determine a wage proposal, we've been looking, and we need to know people's anniversary hire date and for what we're working on. So we need to know our bargaining unit employees' hire dates.
didn't you include that in your records request? And I believe we provided everything that we had.
Well, we'll review that one more time, but I think that was.
Is that true, Paulette?
I think
Okay.
the hire date was included?
No, I'm saying if we don't
Hire
have
date was
a
not
record,
included.
we don't have a record to provide, then we can't provide it.
So are you saying that the county does not know the hire dates of the bargaining unit employees?
No, what I'm saying is under the Public Records Act, we're not required to create a document to provide information that may be responsive to a request for a record. We're required to provide existing records.
So, for
That are
purposes of
public
these
records.
negotiations, are you going to be able to help us out and provide us the hire dates?
I don't know. We don't, to my knowledge, we don't have a record of that compiles that precise information.
Okay, and so that's on the record. So at this moment, we're having a problem for us to know what the hire dates are of employees. Okay.
That's something that if you've requested it, and we can ask the departments that they have that documentation. That's all I can tell you.
That's my guess, is that you'll go to the departments, they're all sitting here, they probably can tell you, but they're all, they probably have some kind of document in their own departments that will tell us their hire date.
I don't know.
Okay. All right, so requested it.
Okay.
Okay, do I need to put that in writing, Mike?
You know, it probably, if it isn't too much trouble, it probably would be
I'll
better
do that.
if we had a record of it.
No problem. I got it. No problem with that. Okay, so then that's the recognition, Article 2. Article 3, general provisions. You'll see that we added some language and struck through a few items there under civil emergency. We also did the same in 3.02. We added some language, and I'll let you guys review that. And it continues on under B for 3.02, and also under the waiver clause, you'll see that we've added some language. Now, if it's highlighted, obviously, it's new language, and ours is simply a strike-through with existing language, if there's a strike-through in there. And that continues all the way through 3.05, accommodations of BCC rules and policies. And you'll see that we've asked for some language that will give us the copies of existing departmental policies, so we've got a full feel of what policies might be out there for each department, if there are any as well. And then you move to union rights, Article 4. Use of facilities, there's some language there that we've added regarding use of facilities. And union bulletin boards under 4.02. You see there's a size change. It makes it a little difficult with a 3x3 to put up some of the stuff we wanted to put up, which is there's not a lot of room, and we end up hanging off the side of the bulletin boards. Along with that, we noticed, and I don't know whether she caught it in hers or not, but we noticed that Public Works Pensacola Beach was not listed as a site for a bulletin board on the original document, so we added that as well. Under 4.03 representation, this is regarding the county, we've added language, the county agrees that the union will be notified on any investigation discipline. You'll be able to read through that as well to determine what we're asking for there. And that continues on through to dues deduction. We've added not only the little language change regarding dues deduction and when we receive payment of dues, but we've, if you continue down under B, C, D, you'll see under D, we've added some language regarding ATU COPE, which is our political PAC fund, which we have one bargaining unit. Transit workers has this kind of language in it regarding political action. Under E, and there's language about assessments regarding to address if we ever have to assess our membership. Moving through under, beyond that, we move to, let me see, I think union leave, under 4.09, union leave pool. And you'll see we've got language there that I'll let you review that when you have your opportunity to review that. It's probably a little different than what you presented across the table. And then, of course, 4.10, notice to union, some language there to provide that to me. As far as Article 5, the grievance procedure, we're just like you, we're trying to clean it up a little bit. And hopefully, between the two parties, we can clean that up and make it more consistent. So I'll let you review that. Article 6, we did not present that to you yet. We're still working on that. And part of that is we're looking at some language to be added, and you might see that coming to you tomorrow, okay?
Okay.
Regarding leaves. And is that leaves or, I mean, discipline, I'm sorry. Did I say leaves? I'm not discipline. Yeah, discipline. And was hoping that we can get a copy of that version of the recommended guidelines to work on it, but I guess we'll have to, we'll reach out to the firefighters or the paramedics.
I don't have it in a modifiable format.
You don't have it either? Okay. Well, we don't have it either. So.
I don't believe they do either.
Really?
We've already
Yeah, they don't
bargained with
either. We
them.
already bargained in the
Okay.
same document we had.
Okay. So let me ask a quick question. Is it your intent to put that in the back of the contract? Is that what your intent is? To move it like to an appendix, or how did you put it? How did you?
Yeah,
I thought it would make more sense as an exhibit.
As an exhibit in the back of the contract?
Right.
Okay,
Appendix.
okay. Might not have a fight there. Okay, so, Article 7, seniority, some added language there, pretty simple stuff. Article 8, leaves, this is one of the ones we're holding out, and we'll give to you, hopefully tomorrow, okay? We're still reviewing that as well. Article 9, personnel records, there's a minor change there. Article 10,
I believe they held out on that as well.
oh, which one?
No, 10, I believe they held out on 10 as well.
Yeah, 9 we
Yeah.
gave them, right?
Right.
10 we're holding out on, and we'll be giving that to you in the near future. 11, we offered up a change. As far as 12, again, I just want to emphasize that we're looking for that information. As soon as we can get that information, where we can get the anniversary or the hire dates, that will help us move forward on our proposal to give you on 12. Okay? Under 13, we held out on that?
No, I believe 13's in there.
Did we give them 13?
No, 13, okay.
Do you have a 13?
The next
No.
one we have is
13,
16.
14, 15 are not
Yeah.
Okay, 13, 14, 15 are not in. 16, you'll see those coming in the near future here on those articles. 16, we gave 16, there's some changes, is that correct? Okay. And you can review to see what we put in there. We gave them 17, there's some copies of pay, regarding pay stubs, as we add some language there regarding that. 18 we held out, right? 18, you'll be seeing that coming. 19. We gave that to them, right? So probationary period, we made some changes specifically, there's some strike-throughs, and you can see that on 19.01. And then 19.03, you'll see some language to address that, okay? Okay? Out of classification pay, Article 20, we gave that to you. You can see there's a change there as well. 21, we did the same with the assumption that we would have a 3-year agreement. 22, we will be giving that to you in the near future, and same with 23. We did add all the appendix, and of course, if you flip through them, you'll see they're not attached. We just assume that once we put those documents to there, they'll be attached, and they'll be listed under, so.
We gotta do some cleanup on that.
Yeah, we'll do some cleanup, but you'll see that we're just doing the same as you, and adding the appendix at the end. There is potential of some more proposals beyond that, but that will be, once Curtis is here, we'll be presenting those. Okay, Mike? That's it.
Anybody have any questions?
And regarding, Mike, regarding this roster that we are trying to get, we did get, the last type roster we got was from Eric Kleiner about a year ago.
Okay,
And the only thing that was missing was the hire dates.
okay.
But there was a document created that gave the individuals' names, their classifications, their pay scale. We're just missing the hire date. And I don't know whatever happened to that document. Maybe Eric deleted it or took it with him, I don't know, but hopefully he didn't delete it. But that would help to get the hire dates.
Do you have the date that you received that?
I can research my emails and get back to you on that. Someone will make a note of that, yeah.
Okay, if you can give us the date, that may be helpful.
To find it, right, that'd be fine. One question, I know these are being recorded, right?
Yeah.
How soon do these meetings get posted up? And I'm assuming, well, where on the website is it posted?
David can answer.
It's on the YouTube site.
It's on the YouTube
County
site.
YouTube site, so it's public.
Right.
And if, depending on what time it gets done today, usually the same day.
Oh, wow, okay, very good.
We've done them all, I think, within 2 hours of it, but he has a lot to do today, so it may
Sure.
take a little more time today.
Sure.
He has multiple meetings.
Sure. So I think this is probably the point where we're gonna break apart, isn't it? Because we're gonna have to review what the documents have been presented on both sides, right?
I think so. Maybe what we do is this, before we take that step. I think, Mike, you were going to get with your team and maybe try to call Curtis and give us some feedback as to whether you're going to proceed with some kind of agreement on the 3% today, or.
Yes, we were.
Or wait till tomorrow. So I think that's something that you need to do. And before we all walk away, if I could have an opportunity to caucus with my team, just in case they have any questions or
Yeah, no
any
problem.
other business.
No problem. And that will give me an opportunity to call them, and then we'll come back with that answer as well.
Good.
Okay?
I'm just happy to be here.
You're happy to be here, yeah?
Well, we appreciate the opportunity to take a caucus. We went through the material you gave us. There's a lot of things that we have to consider and analyze, price out, but you know, I think we can maybe go through 1 through 7 and talk about your 1 through 7.
Okay? Well, we didn't get to 7, but we will see how far we get. We got through 4.
Okay.
Okay, and then, 5 is a little bit more of a intense moment to discuss for us.
Yeah, okay.
So, but we can start with 1 and work our way through. That's fine.
Okay. So.
We had to drive, you understand me? We had to-
Yeah.
We had driving time too, so.
I think both of us are making the same change to Article 1, which is referencing Local 1395. And I think we're both pretty much on paper in agreement on Article 1.
Yeah, the only thing I think that, I'd have to double check the certification, but the AFL-CIO part,
Yeah.
I don't think that's a big deal, though. If that's on
you're
there.
affiliated with them, I don't.
Yeah, if it's on there, on the PERC certification, then we'll,
Even if it's not,
Yeah.
if that's what you want to put
Yeah.
in there, you get to decide what your name is.
right.
Article 2, I think we all agree with the fact that those are the PERC certification cases that defined this particular unit, and that the most recent one was June 1st, 2010. And I think we both had a conversation earlier today that we're going to look into any appendix that would be attached to this contract to make sure that it is lined up with the actual order, and if the order has to be clarified somehow, then we'll work toward that, because if there's been title changes or
Right.
positions that have been added to the appendix list that shouldn't, or whatever, we'll have to get that all straightened out.
No disagreement there.
Okay. We have concerns and can't agree with the current language that says we will make no change to a job description, because sometimes we may find ourselves in a position where we would need to assign different responsibilities to a person. So that's, that language at the bottom of 2 in your proposal is problematic. In moving on to 3, and I'm just running through this pretty quickly.
Yeah, I see that. Go ahead.
You have put the word "only" in 3.01 under civil emergencies, saying that the provisions of the agreement may be suspended by the BCC only during a declared emergency, and we understand that.
Okay.
I mean, we're not suggesting that if there was not an emergency that we could
Right.
suspend that. I'm not really sure why we're taking it out permanently. I think what is the intention of having the word permanently in 301 is that during an emergency, there are people that are working in their regular workplace, and then there are people that are temporarily assigned in that workplace. And permanently or temporarily is just trying to capture both of those groups of employees.
Okay.
So if we just said temporarily, then only the temporarily reassigned employees would be impacted by this. And what we're really saying is both those who do and those are reassigned into that job
Okay.
would be covered. So we
Thanks for the
think,
clarification.
we think permanently might be good to stay in. We're going to have to talk more about on-call. We had a conversation in our caucus, and we're going to have a more elaborate conversation about that. We have a concern about the language that's proposed for 3.02, because we actually think we may be infringing upon someone's free speech. I think someone can offer a personal opinion about a union. But that's just kind of our first blush at it, you know?
Okay.
We also have a problem with 3.4B, I'm not really quite sure what, let me ask you a question. 3.02B, is that suggesting that it says, any claim of discrimination or sexual harassment by an employee against BCC shall only be subject to the methods of review prescribed by law or rules. So I think what that's saying is that we would like to see discrimination actions, including sexual harassment, to be addressed by those agencies that are experts in those areas. which would be the Equal Employment Opportunity Commission, the Florida Commission on Human Relations.
Right.
Maybe even a local one.
Right.
So by putting the anti-discrimination clause in here, are you taking that away?
Oh, that was a discussion that we had looked at, yes.
Okay.
But we're not saying that, let me, I think once we get our position out, you'll understand where our concern is.
Okay, all right,
Okay.
good. We have a concern about okay, this, again, I'm just asking a question. I'm not trying to put anybody on the spot. So if you want to defer, that's cool. But we were wondering, what was the problem or the circumstances that triggers the language at 304B, where, on ratification?
So,
But like I said, I want to put you on the spot, but.
well, let me just scan it for a second. So, one of our concerns when it comes to the interaction of management and the union, when it comes to dealing with issues of, reaching, we understand that statute 4447
Right.
kind of lays out the way you go through the process. But historically, there's a lengthy process that I've seen all the way back to 2001, when I first got involved with the county, is that there often is a lack of communication, that there's an action taken by the county without even communicating to the union that we're taking this action. And we tend to find out after the fact. And so then, for instance, using the example of the MOU, an MOU is sent over to us by email saying, here's a 3% raise. You've got till the 15th of October to sign off on it. And from our perspective, we're thinking that process is not proper. We think that if there's some kind of change that's being done in the labor agreement, or some action that if the commissioners are interested in making an action that will either improve or change the terms here, that you would be contacting us before you actually take an action of sending over, for instance, an MOU, and saying, here it is, this is what we're offering. The outcome of this is what we're facing right now with the wage reopener. We think the proper process would be that you contact us and say, look at Mike, we want to give you guys a 3% raise. Great. Okay, that's fantastic. Let's sit down and talk about it. Instead of going through this dialogue that we're facing right now, which is you sent over an MOU already signed by Ms. Gilly, and we're sitting here going, wait a second, we haven't even discussed this. We haven't even understood what your reasoning is, or had any dialogue regarding the language that's in the MOU. Instead, we're asking to do that up front before a commissioners can even ratify or approve something like that. If that is something that affects the labor agreement, we feel that should happen on the back end line. So once we reach a tentative agreement at the table, where both sides have signed a TA, because that's been a problem, then once we sign a TA, then it goes before our membership or our bargaining unit for approval. And then we would suspect it would go then in front of the commissioners for final approval. But that's, what we think is the proper process that should be done.
Well, okay, we really, we're asking just for what your thought processes were that led to that, so I think we understand that now. Does anybody have any questions about that?
No.
Okay.
So,
All I would just like for a point of clarification, it was my understanding this was the 7th year in a row of a 3% increase in salary. Is that correct? A 7th year in a row of a 3% increase in salary by the board to the employees? I'm just asking for clarification. 7th year in a row?
I believe
of
that's
a-
true.
Okay. So from that perspective, it probably wasn't a surprise. It happened before I came, I would say that, during the budget conversation, but, so, the action that was taken was based on what I had seen as previous action that was provided to me. So it wasn't an attempt to do anything untoward from that perspective. So I would just like to clarify that, because I think 7 years in a row of a 3% might not be a surprise.
That's not, the 3% is not the surprise part. The surprise part that kind of is the communication process, that we're trying to say to you, to us, what's cleaner is that as the administrator or as the county representatives, you would contact the union and say, look, we're looking to give a 3%. Our first reaction would be, great, let's sit down and talk about it. And then from there, an MOU would be created between the two parties through discussion. Last year, there were MOU, same process was thrown at us by two different bargaining units, and we responded with counters to those from last year. And it ultimately came away with a final MOU. It was a little cleaner last year, different. I dealt directly with Eric Kleiner last year, and we were able to process and get the MOUs taken care of. We're just wanting to say that we think it sends a different message to us that when you just kind of say, here it is, you got to the 15th to agree to it, and then we say, well, hey, here's a counter, or let's meet, let's discuss. Well, we'll wait till negotiations on November 5th and 6th. It sends a message to us that, okay, it was either take it or leave it. Not saying that that was your intent, because I don't know what your intent is, but I feel like it makes the relationship better when we have a better dialogue regarding it. For instance, to this day, we're not sure if it's a COLA or across the board. Even though it says across the board, we're still wondering, if you look out into talking with the other unions, a lot of them say it's a COLA. And I said, no, it's not a COLA. It doesn't say COLA on it. It says across the board. But people are perceiving it as a COLA. And it clearly isn't in the language in the MOU. And so what we wanted was a clarification of what you meant, and which was stated earlier today, of what an across-the-board raise is.
Correct.
Right. From your perspective, which you added and clarified something that was important to us, which was the starting wage, which was part of one of the questions that we had from the very beginning. You know, is this affecting a starting wage? So, because we think there's some history there that we might want to talk about in the future about that, so.
Okay.
The only concern that I have, considering how we've interacted historically about this, is the process is very formalized in the contract. And there has been times when I know the county has a desire that's shared by the union to do something on a particular timetable. And I could think of one example that I'll use, Mike, that I think involved the two of us, but I think, and I'm going back into ancient history, but I think in 2011, the legislature passed a law requiring FRS employees, including the county, to make a 3% contribution. And then quickly the commission said, we don't want to have people falling back because of this contribution. So we're going to actually make an adjustment to their pay so that they net out even. And I think I came over, we called everybody in, and one by one, and it was like, literally, it was like one pay period away from when it was going to hit. So we already had the approval of the commission, so just by the two of us signing it, payroll went ahead with that, I think. So I think sometimes the circumstances call for both of our interests to want to be a little more flexible in this.
Well, that example obviously was changed by the state, in Tallahassee, that was changed.
Yeah.
So we didn't have much of a choice, because I think the that date was July 1st, I'm not sure.
I think it was.
And so we didn't have much of a choice there, because otherwise it was going to affect people. The difference with this is using the wage issue here is, let me just put it out there and be frank with you, some of the concerns.
Sure.
So once the MOU was sent over, I responded to it, and then there was a response back, well, we'll wait till November 5th and 6th. There wasn't any other dialogue beyond that. But out in the ranks of the people, there's been a lot of conversation about it. As of even yesterday, I'm getting calls of people asking, why didn't the ATU sign it? I'm having to explain that to them. Because, as I stated earlier, the ATU feels that every bargaining unit employee has the right, it's a wage increase, that's what that is, it says wage increase in the MOU, has the right to vote yea or nay. That's what the statute says, they get to vote for it, right? They get to determine whether they want, because there might be a group of people at solid waste, I see Pat behind you, that saying, well, we think we deserve 4%. I don't want to get myself in a predicament where I've signed off on an MOU and we didn't give them the opportunity to voice that opinion. And so we think through collective bargaining, through the meeting, the sitting here negotiating, that's all done with the TA. When the TA is done, that's what they're voting on. And we think that the process should have happened earlier than October, maybe a little bit sooner, or as soon as maybe it was approved. That's why I asked for the date of when the commissioners approved that 3%, because it could have started then.
Yeah, well, if we'll.
Immediately could have started discussions of when that 3% could have been.
We'll get you that date.
Yeah, I understand.
I believe it was September 18th, but don't quote me on that.
And that's fine.
Sometimes that's how it has to happen.
Yeah, I understand, but we think the faster the discussion occurs, then, that's what helps it. It helps resolve it because we can go through the process cleaner.
We can find the date.
But what has happened is there has been some information that's put out to the workforce that's misleading, and they're thinking that we're deliberately not signing the MOU for whatever reason, but we're not, it's not that we don't, trust me, 3%? Hey, there's a lot of people who say 3% is great. If I'm making $19, $20 an hour, 3% is pretty nice, right? But that, they're waiting for it because they get a nice increase of about $1,300, $1,400 a year in their paycheck. I understand that. We just want to make sure the MOU language is clean and everybody understands the intent of it, and there's a TA on it, of some sort that before we approve it, which would be the final signature on the MOU. That's all we're saying, Mike. And we think that that should happen for every type of action that's done that has to be bargained.
Okay.
Okay?
We understand, at least, well, we understand your thought process. I don't know what we're going to counter in terms of contract language.
Okay?
I guess going on to the next issue, I think C, 3.04C, is part of our conversation we just had.
Sure.
So 3.05, we like our language for 3.05 better. So we're probably going to stick with our counter of 3.05. So then 4.
Let me just take a quick look.
Yeah.
Oh, the accommodations of
No. It's
3.05?
It's, yeah.
With the rules, and you took
Yeah.
out rules and, yeah, okay.
So the terms and conditions remain in effect unless notice of a change is given to the union prior to the effective date. At the union's request, the county will agree to negotiate any change that impacts negotiable terms and conditions of employment. The parties acknowledge and agree that the terms of this provision will apply to BCC policies that impact mandatory subject bargaining.
So look, can I jump in here real quick?
Yeah.
Our thought process on this is pretty simple. Obviously, if we look at a rule or a policy, whatever you put out there, we're not saying that, once we receive it, we'll determine, okay, that's not an item that can be negotiated. The county has the right to create that. We're good to go. Thank you for sending it over to us. You're going to probably have the commissioners approve it, move on, right? But we are saying that once there is some kind of rule or policy that comes to us and we look at it and we say, whoa, wait a second now, this does impact the terms and conditions of employment. We would like to have that period, that's why we put in, I think, is this the one that has 30 days? Yes. Well, we put in a period to allow both parties to meet, discuss it. Now, it doesn't mean that you're not going to try to approve it, at some point, but it means that at least we met, we discussed it, and we look to, and hopefully, if the relationship's going strong, we'll come to some kind of agreement that everyone can live with, and then it will be put into place. That's all we're saying. We're not trying to say that you can't, we're going to be sitting here trying to negotiate every single rule and policy. That's not what we're saying. Only if it impacts the terms and conditions of employment.
Well, I'm glad to hear that, but we still like our language better.
Okay.
So 4 is, we're pretty far apart in some sections of 4, particularly
Can you go back to 3.06?
3.06, sure.
Can you just give us a description of what that is right there, real quick?
2.06.
In your,
Standard governing law provision.
I think that's just a statement of the law.
okay,
I mean, it's like the example of the 3% contribution.
right.
They put it in, they enacted as the Florida law over in Tallahassee. We all have to obey the law.
Okay? Okay, we'll shoot that over to Mark. We'll take a quick look at it.
Okay?
Okay?
4, we have a lot of differences in 4, although I do want to point out that there is a sentence at the top of page 10, right above 4, which says the county agrees that if a bargaining unit employee invokes their Weingarten rights, the county will honor such a request as required by law. Obviously, we would agree with that, so.
Okay, we just want to make sure everybody understands that. That's all. So maybe if it's in the contract, that it would help everyone.
Yeah, so yeah, we can certainly agree with that sentence. It's the rest of it that's more problematic.
Well, and we have a little problem with yours as well, so, but we can work our way through. I hope that we have dialogue on this. So go ahead.
So 5 is, 5, I think, those who agree.
Oh, wait, you're on 5.
No, I'm talking about 5, yeah, because we have a 5.
Okay, we didn't get a chance to look at your 5, but go ahead.
I'm just going to say, I tabled the 5 too, because that's kind of just something for those who handle grievances and arbitrations to really focus on, because, it's a process, really.
Yeah, we're hoping that I will say this, we're hoping that that this will come along and make it a little smoother for both parties to understand. I agree that sometimes, sometimes language gets in there that makes it more difficult to act on it properly. I will say upfront to you, since you're looking at our 5, that we think it's kind of one-sided right now, and we don't think that's fair. We think that for it to, it almost implies that you don't have to respond to some steps, which we think that is what hurts the grievance process. You've been doing this a long time, Mike.
It's in almost every contract.
Right, and a good grievance process, and the people that utilize that grievance process know that they don't look at it as a bad thing, in my opinion. If you look at it as a bad thing, then you're always going to say deny, or you're going to write grievances for no reason. When you look at it as the ability to sit down and have a discussion about what happened to that individual or individuals, and you have a discussion of maybe we're not looking at something that we should have been looking at. And you can resolve it in some cases, right?
Right.
Not saying in all cases, because obviously there are cases of discipline that occur that they did it, right? But often I see grievance processes where it's noted by both sides that we never saw that one coming in that situation. Wow, this might be a better way to make the organization stronger, right? So I also believe that seeing language that says that if we don't reply, and it just moves it to the next step, it's going to continuously be pushed up the ladder to the administrator. And I don't think that's what she wants. I think she wants it sometimes resolved at the lowest level with the directors. And I think that that's important. Not saying that the directors haven't replied to grievances, because you have, but I just think that the language needs to be cleaned up. I also think that the time frame of the grievance it's so lengthy that, you get into a grievance process as the grievant, and you're sitting there a month later going, where's my grievance at? And I think grievances should be handled in a more timely fashion. That's why we propose to cut some time in there. So that's just some input for you to take a look at.
Well, we would all agree on this side of the table that every step of the grievance process should be followed, and that if something can be resolved at a preliminary step, it should be resolved at a preliminary step. And in the annals of time, I'm sure there's lots of grievances that could and should be resolved at a preliminary step. The problem I have is that sometimes these things fall through the cracks, because grievance responses, it is not each of these management representatives' first job, right? So they might not get a grievance for months, and then a grievance hits. And we want them to consider those grievances and respond honestly to them. But if something falls through the crack, we're going to have a hard time saying the relief requested is automatically granted.
Okay?
That's that's going to be a hard thing for us to do. If we wanted to construct a process that you thought was more interactive, we can do that. But the real problem I have is, because I have seen them fall through the crack. You've seen them fall through the crack, you know. Somebody's out, or somebody just has never done it before, and so
Right.
And, you know, we can't have somebody coming in saying, I want, some significantly expensive relief, or someone who really does warrant some discipline, be completely exonerated in the face of misconduct because of a clerical mistake.
Okay, so I hear you on that, and I'll take, we'll discuss that. And the one other area of the grievance process, since you're on it, that I kind of want to touch base with you on, is the idea in the very first paragraph that grievances have to be written as a violation of what's in the contract. You know, often there are policy violations that have been done to employees, and the process of clearing that up, they want to go through the grievance process of the union to have the union help them present that concern.
Yeah, well, that's how we view a grievance. We view a contract grievance as the enforcement mechanism of the contract.
I understand, but I think you can see where we want to have that changed.
Okay, well, that's going to be a tough one, but we can certainly talk about
I
it.
hear you, and just, for FYI, since the administrator's in the room, the young man that filed the grievance in Wes's department regarding the promotion process, it was very disappointing for him, because in the end, he wanted to voice his opinion, and he wanted to be able to say not only to Wes, but he wanted to present it to the administrator. Now, he understood your position, and I explained to him, look, we're kind of stuck in a catch problem here. We're not going to be able to take an action on this, but he felt like he was cut out of the process. And when there's always two sides to the story. And I know in front of the county commission, we heard Wes go up to the mic and give his version of it. And of course, I was kind of put in a position to give Adam, is it right? Adam's version of what happened. And even afterwards, Adam told me a little bit more. And I'm like, wow, Adam, I didn't know he was really committed to getting his CDL and ready to do it, had designated the money and everything. But the point was, he wanted to come to her to say that the system was not in order of what it historically had been. Now, whether you believe that or not, or whether you agree with that, that's another thing. But in this situation, I felt like that bargaining unit employee, that union member, he felt like he was cut out of the process, and he didn't get a chance to voice in print. And unfortunately, now he's a little bit disgruntled about that. So that's why we think that when there's a policy violation, because that was a promotion process that was in the I guess your SOP in your department, and he felt that he didn't get to, and that was a practice that he felt that was in place, and he didn't get to express that. So that's one of the reasons why we think that the grievance process should be changed. But go ahead.
Just a couple, I'm bouncing around a little bit here now. On Article 7 on seniority.
7. Okay?
I know that we're gonna have a disagreement, like I think we have in other bargaining tables about how seniority is used, but I wanted to have this observation. Actually, I don't think what we have put on the table, and I don't think what you've put on the table, is capturing the current practice for seniority at the county. And I think we probably should change the language. We'll take a stab at it to change it, because the way this county works is that if you leave county employment and you return within a year, they actually will capture your first term of employment and continue your seniority.
Oh, okay. Didn't know that. That's interesting. Okay.
Okay. Does that make sense? Do you
Yeah,
understand?
well,
what
I hear what you're saying. You're saying, so, I mean,
So like, let's say if I would work for the county for
Right.
5 years, I left for 6 months, I came back, I worked another 6 months,
you lose 6 months.
I'd be 5 years, 6 months.
Right.
If I go over a year, I go to 0,
But it's only after 1 year.
1 year.
Anything beyond 1 year, you
You're
start
back to
as a
0.
new hire.
Yeah,
Okay, well, that's something that we'd like to hear more about.
okay. The other thing is Article 11, management rights. Let's see what our management rights is. See if there's something in there. We have some new language in our Article 11.
Yeah. Briefly saw that.
Yeah, that we would like to see, but, and we made a housekeeping change by changing the reference to bureau to department, but you do the same thing. So we're both on the same page with using department or division. Taking out the word unilaterally, adding for just cause, we probably won't have a problem with either of those changes.
Okay. Okay.
So that's what that takes us up to 11.
Let's review that paragraph and then
Yeah.
we'll get back to you.
So that's about, I just ran through 11 of
So we go back to union, to Article 4? or-
11 out of
Or did you not want to talk?
21.
Okay.
I just ran through half the contract.
Did you?
Yeah.
Okay. Well, can we go back to 4?
4, sure.
Because we have questions too, so on 4, need some help on, or just some dialogue here to try to understand your thoughts and why you're saying this, okay? So in 4.01, the use of facilities, there was quite a bit of strike through, in fact, the whole article. So what was the thought process of striking all the way through?
Do you want to take that, answer, Chris?
Well, we built in language in the next paragraph that provides the union with access for the bulletin board. And beyond that, I don't know what additional access the union would require.
So are you saying that the union doesn't have the ability to meet workers on their lunch break in a lunchroom or something to that effect?
I
Where
didn't say that.
I'm just asking, I'm not, you know.
I was asking, I don't know what additional access the union would require. Obviously, they're not going to be holding meetings
No, we're not
on
gonna.
county
no,
property.
no, But,
So other than that going to maintain the bulletin board, I don't know what, and from talking with the directors, they weren't really aware of there being any additional need for the union to have access to county facilities. But there is always the opportunity for the union to request access if they wish for a particular purpose.
okay. Okay, I'll think about that a little bit, because, I can see, running through my mind, I can think of a couple reasons why we might want to have the ability to talk to workers not on the clock. We would never attempt to try, let's just be realistic. I don't think anyone's seen any activity of coming on and just going crazy on your location, I don't think. I mean, we try to do it when they're off the clock, okay, when we want to reach out, especially if they have questions, they want to ask us a question. And if, especially if, maybe they have an incident that they're concerned about, and they might say, hey, is there a way you can meet us? On lunch break at 12 o'clock or something like that, I'll say, sure, we'll meet with you. And, I only have 30 minutes, okay, I'll come to you, okay, I'll come to you. But, no, do we hold meetings on the property as far as union type?
No,
meetings?
I knew that
No.
wasn't the
No.
case.
So, okay, so I understand what your thought process is. Okay, so let me just look, and let me think about that. We'll come back to you. Thanks for the clarification. 4.02. So you're wanting us to provide you a copy of everything on the union board before we post it? Is that what I read?
Mhm.
And why is that?
So that the county is aware of what's being posted, to be sure it's appropriate.
Okay. Have we posted anything that's been derogatory in any way?
I didn't suggest that you had.
Okay, so, and then you're saying you want 24-hour notice. So if I have like an emergency meeting with workers, I need to post real fast, I have to contact you to post that up. Is that what you're saying?
Well, you could counter with different language,
Okay.
if that's a concern.
It just seems kind of controlling, that's all. I would understand if we had a history of posting things that were derogatory up there, that like.
I don't know what the
that-
history is.
Well, I'm sorry, but maybe the department directors can help, but I can assure you that since I've been involved, I don't post a bunch of derogatory
I
stuff up there.
didn't think you would.
No, I don't, but I also don't want to limit our ability to be able to control the union board, which we feel is our way of communicating to the workforce. But that's, okay, I understand your intent. We're probably not gonna be able to communicate. Can I ask a question on the listing of union boards? You have one here, it says Public Works Santa Rosa Island, I'm assuming that's the beach, correct?
That is the beach.
Okay, so, let me look here real quick. Which one was it that we were looking at that caught our attention? Oh, so you struck through the downtown governmental complex and the judicial complex.
I was told by the directors that there weren't any bulletin boards and there weren't any bargaining unit members at either one of those locations. Is that correct?
Well, there's one.
Where?
There's one employee at both of those locations.
Oh, do we have a bulletin board? I thought we had I don't believe there is. So I was just trying to be accurate in terms of where there's actually a bulletin board
Okay.
and a bargaining unit
Yeah,
member.
so at the judicial building, there's about 5 employees there. Custodial, right.
Custodial.
And there's a bulletin board in their break room.
I didn't know that.
Yeah, and then the downtown complex, I will agree, is very difficult to get to for me. I tend to end up leaving the notice with the guys at the front desk to give to whoever the facility guys is. And that, so, because the location of that bulletin board is behind a secure door that I can't get to unless someone lets me in. So we'll talk about that one, because that one can be a little frustrating for us. Okay, very good. So obviously in 4.03, we've added some language there, but, we didn't hear you respond to that, but I can assume that your non-response is that you're still contemplating it or looking at it. 4.04, dues deduction. So, again, I'm looking at Lorraine here. Hey, Lorraine.
So I just cited to the statute.
Yeah.
And I think that captures everything that we're legally allowed to do in terms of handling dues deductions.
And that part I get. I understand what you're trying to do there. So the question is the turnaround of the actual dues to us. So we want to have just some further discussion, but I'll wait for Curtis to get into that conversation, okay? And how we feel about that, okay?
What do you mean by that?
So, she's not in the room, so I don't, maybe I shouldn't jump into it until she's back in the room. And when she is, maybe I'll let her cite to you her concerns, okay? I think that'd be the safest thing to do. For me, I might be misquoting what her thoughts are on that, okay? All right, so then we move into, let me just look. Let me go to union leave pool. Just a question, I just need some clarification of what it says there. Can you, tell me if I'm misreading this and if I've got it wrong. Are you saying, out of the 120 hours, after that, there is no more union leave? Is that what you're saying, period?
Correct.
So when the union leave pool is exhausted for this unit, there's no more union leave after that at all? I'm not talking about the union leave pool, I'm talking about union leave, period.
Correct.
So during negotiations here in this session, right, we're down to 80 hours now because we have 2 individuals in here. Pretty quickly here, we'll be down to 0 through these sessions. Then you're saying beyond that, they couldn't attend?
Well, I suppose they could use their own leave.
They would have to use their own leave. Oh, see, you were right. Okay. That's interesting. So you're saying even if the union were to pay their salaries or recompensate them for their time, even if it's no expense to the county?
I don't know about that. There isn't any language in this contract about leaves of absence. However, I do believe the county has a policy for employees to take a leave of absence without pay, but I suppose would be subject to the terms of policy.
Okay, well, that helps us to maybe resubmit some more language on ours to hearing what her position is, okay?
Okay.
So, boy, if this was in effect,
The contract currently provides 120 hours.
correct.
And nothing beyond that in terms of paid union leave.
Mhm. So, I think that is not doing justice to the workforce,
That's
allowing them to
actually,
be-
other than the ECAT contract, that's the highest.
Yes, of any of the other bargained units.
And I'm not, Madam Administrator, I'm not arguing the 120 at this point. I'm not kind of going there. I'm going more on the idea that they can't take additional union time without pay. And that's where I've now got her position on that, so now I know it, what her position is clearly. Because, and while the union hasn't utilized that as much with this unit, right, for the last few years, we haven't. I just think that is not, that doesn't allow for good representation of the workforce. I mean, there are, the ability to be able to represent your unit can also be paid for by the actual union, to be pulled off without pay, to represent them. But I understand the position now, because 120 hours, I'm gonna say within 2 or 3 sessions here, it's gonna be gone. And then, if this was a year out from now, after this contract was ratified, these guys would have to go back to work, and it would be just myself and maybe Curtis sitting here trying to negotiate their contract. And that's not the intent. We want representation here of the workforce, because, they're giving the input. They were elected by their peers to be in this room to negotiate. And then it eliminates throughout the remainder of the fiscal year, it eliminates the ability to represent. For instance, if there's grievances, they wouldn't be able to even go into a grievance hearing. So unless you literally took them in, the management. So that's concerning, that's concerning.
Well, and I did want to clarify one thing. This is not her document. This is this team's document.
Oh, okay.
So I want to make that, in case we've misstated that.
Oh, okay, well, I'm sorry, because I appreciate that, the team.
I felt
Saw a lot
like are we here as a team?
We are.
Okay, we're a team.
So, I will say that if I construed that it was herself, I just assumed because it was referred to her that that conversation was supposed to go directly to her, that's all. Because he
Okay.
referenced to her, and.
She just knows a lot.
She knows a lot, sure.
She has the typewriter.
Sure. And, now, I will say that if these negotiations go further, and we're gonna run into a point where, you know, if these guys can't be in the, you know, not saying that at this moment, I don't know what your position is. I'm assuming I know your position, but if they're not allowed to be in here, we're gonna be negotiating on Saturday morning or after, late at night. We're gonna have to, because that's the one, I have to have them in these negotiations with me. They were voted on by their peers to be in here, so I think that's important that they're in here. Okay, so, just so you know. But, not that I haven't done late nights. I don't know about you, Mike, you've probably done a few. And I've done some Saturdays, so
Yeah.
that doesn't bother me, so. All right. All right, so that covers that. Let me just take one more glance at this. Okay. So that covers 4 for me for now.
Okay, good.
And again, we didn't have enough time to go through other articles.
I understand.
You know, after we grabbed our sandwich, we got to the hall, we sat down. We were able to go through, and I will admit that 4 kind of held us up a little longer, we thought.
We have, Kristen, did you want to talk about?
Yes.
The thing?
Yes. First off, I did confirm the board approved a 3% increase at the final budget hearing on September 23rd.
September 23rd?
And in response to your concern about gathering the dates of hire for bargaining unit members, we had some discussion during our break, and the options in terms of what the Human Resources Department could provide in terms of existing records would include potentially 2 options. One would be a copy, which you probably have, of the Evergreen report, which would include the entire county up until the date of the report in 2016. That would include dates of hire. Another option would be, and this would be somewhat labor intensive, would be to take the list that you were provided that HR did have of the bargaining unit members, which didn't include the dates of hire, and then use that list to go and pull each individual personnel file and copy off the personnel action form that lists the date of hire in each file. That could be costly, but it could be done. The third option, which may or may not be possible, is if in the clerk's office, from talking to them, they are able, if they have a canned report that could potentially capture that information, then that would be an option as well.
Okay. I'll discuss that with Curtis tonight when he flies in, and see, and tomorrow morning he'll tell you which way we're hoping to
Okay,
go.
good.
But we need it. We definitely need it. You know, one of our proposals, we can't move forward with it without that, because we're calculating, you know, we're running numbers, and we're trying to, it's tied to that date. So,
Okay.
Well, and the complication is just trying to figure out what record may exist that would contain what you're seeking, and that's what we're trying to figure out. So we're trying to work with you on this.
No, we appreciate you working with us, because, you know, we obviously know that you have that date somewhere. We did, you know,
For
where it
each
is.
individual, but that's a matter of calling a record that would
Right.
contain that information. We don't have an existing report,
Right.
like a spreadsheet, that would include all the bargaining unit members and all their dates of hire. It doesn't exist.
Right. Okay. I will say that years ago, you had it. You had a report that was really, you know, back in the day, Mike. It's been
According to
years.
Paulette, she has searched the HR records,
Yeah.
and what she provided you, I guess it was a couple of months ago, that's all that HR has
Yeah,
in their
this was
records.
before the unit was turned into 1771. I'm going way back into early 2000s, when we used to have a spreadsheet of the bargaining unit. It was updated pretty much monthly, and it gave all the information we were looking for. It allowed us the ability to reach out to these people as well, not necessarily having to capture them while they're on the property, but to be able to send them a nice letter or something to that effect. effect to say, hey, you know, you're part of the bargaining unit, and here's a copy of your contract, or, you know, we'd like to talk to you, that type of thing. But more importantly, it had the date on there that we're looking for, which is the hire date. Because we're looking at the classifications and the different pace.
So I
structure.
think the information that Paulette provided you before had all of the other information you
Oh,
were
yeah.
asking for,
Yeah,
correct?
I utilized it, yeah.
Okay, so
I
all you
utilized
need,
that for part of the-
all you're
part of
looking
it.
for then is just their initial date of hire.
That's correct. That's what we're, at this point, that's all we're looking for, yes. So why don't we, at this point, why don't we call it a day and come back tomorrow at 10 o'clock? And-
Sounds good.
And then I think we understand what we're supposed to be looking at. I know you'll continue to look through the agreement, our proposals as well, and we can continue from there. And Curtis will be here tomorrow as well.
Okay, Mike, sounds good.
Thank you all for your time.